Hello, everyone. My name is Lucero, and I will be hosting this session on behalf of HISPANIC. Before I introduce panelists, I just want to thank you all of being here on a tough night due to the COVID-19 situation. First of all, I want to say thank you to Traye for providing us with the means to bring this together through their online platform. I also would like to remind you to write your questions in the Q&A panel. And at the end of the session, we will have 15 minutes to answer them. Now, I'm really happy that we have Antonio and Nadia to talk about COVID-19 rights and duties in the workplace. Antonio is the Canadian Hispanic Bar Association membership director and lawyer who helps the owner manage business to control operation costs by organizing employment relations out of COVID-19. Nadia Halum Arauz practices employment law at a boutique firm in Toronto, where she assists both employers and employees navigate their rights and responsibilities in the workplace. So without further ado, I will now start with Nadia. Please start the presentation.
Hi, thank you. Before we get started, we just had a few statements and disclosures to make. So obviously, in light of everything that's happening, we want to acknowledge that and obviously the discrimination that is still very much a part of everyday life and is embedded in the inequalities in the services and education that we receive. And while there's been progress in our laws and our laws have changed, they're not universally applied. So to all of our friends and allies that are hurting right now, we want to know that you are not alone and we stand with you in this fight.
And before we go to the presentation, Nadia, and the disclaimer that you are looking forward to read, I would like to recognize that we're broadcasting from the traditional indigenous territory of the Wendat, Haudenosaunee, Anishinaabeg, Chippewa bands, and the Mississaugas of the Credit, COVID 13, William, and other Upper Canada treaties. These are home to Indigenous people, and we wish to express gratitude to all the First Nation, Métis, Inuit people who have been living on the land since time immemorial and give us the opportunity to meet and work on these territories.
Okay, so now for a more presentation-related disclaimer, as Lucero said, Antonio and I do practice employment law. However, the content of this presentation is for general guidance only. The application and impact of employment law can vary widely based on specific facts involved. And as Lucero said, there is going to be a time for questions at the end, but just so everyone keeps in mind, the presenters and the organizers for the purposes of this presentation are not engaged in rendering legal, accounting, tax, or other professional advice and services beyond legal information. And this presentation should not be used as substitute for consulting with any of those professionals. And of course, before making any decision or taking any legal action, we recommend consulting a licensed legal professional, hopefully either Antonio or myself after this presentation.
All right, thank you, Nadia. Let's start with a phone poll. Let's launch this poll, and we would like you to answer whether you're in either of these three categories. We'll give you a few seconds or a minute or so to answer. Are you an employee? Are you an employer? Or are you self-employed?
And as Lucero mentioned, we practice both sides, but it will be helpful for the purposes of today's presentation to know kind of how our audience is composed today. So we can wait a little bit.
We have 4 participants to go. We have a few answers so far. Employee 50%, employer 17%, self-employed 43%. All right. I'm gonna end the poll in the next 6 seconds. And ended the poll right now. The total was 8 votes, 50% employee, 13% employer, and 38% self-employed. Let me share the results with you so you can see it. And let's move to our next slide. All right, Nadia, I'm gonna give it back to you in a second. I just wanna share the agenda for today. We're basically going to cover 3 points, major points of what's going on with COVID-19 in the workplace. We're gonna start with health and safety. These are 2 sides of a same coin, which is the infectious disease controls from the employer side and the right to refuse to work from the employee side. We're going to talk about the government emergency responses so far for employers and employees, like the wage subsidy work sharing programs, work interruptions, like temporary layoff, terminations, and what you like to call, Nadia, IDEL, infectious disease emergency leave. And then we'll finish that. We're going to open for questions and answers. And at the end of the presentation, we will have a few slides and use resources. So we hope you enjoy it. Please send your questions. We'll be happy to try to answer those. Nadia?
Yeah, so the first thing we're going...
Sorry. We have a poll number 2. I like polls. Let me open poll number 2. Here we go. So for poll number 2, as an employee, what are you concerned about when business reopen? Not having enough supplies for personal protection equipment, contracting COVID-19, businesses not taking enough precautions, traveling to and from the workplace, or none of the above? Let's give you a few seconds for answering that poll. We're going to talk about this, right, Nadia, with health and safety, preventing the spread of COVID-19 in the next slides.
Yeah, definitely.
So people is answering. Thank you for your answers. All right. So far we have contracted COVID-19, 56%, businesses not taking enough precautions, 20%, and traveling to and from work, from the workplace, 30%. I'm gonna give you 3 seconds and I'm gonna end the poll now. Let me share it with you. Can you see it, Nadia?
Mm-hmm.
Awesome. So you see there, contracting COVID-19, 50%, traveling to and from the workplace, that means commuting, 30%, and business not taking enough precautions, 20%. All right, thank you for your answers. And Nadia, up to you.
Right, so when we talk about health and safety at the workplace, the main legislation that we're discussing is the Occupational Health and Safety Act. It's also referred to as OSHA by a lot in the employment law field, so I'll probably be referring to it like that as well. But essentially, it sets out various obligations for both employers and employees. And some of these obligations are very specific. So for example, workplaces that have 5 or more employees need to have a health and safety policy. That policy needs to be reviewed. It says at least once a year. So it can be reviewed far more than that. And I would argue COVID is definitely a good excuse to review that, that policy. Also, there is an obligation to have a health and safety representative if the workplace has 5 or more employees, or a joint health and safety committee if the workplace has more than 20 employees. So these are examples of very specific obligations that Antonio and I thought are directly related to what's happening now. But there is an overarching obligation, which is the first one under point A, which is to take every precaution reasonable in the circumstances for the protection of a worker. So that means even if there's nothing specifically in OSHA that says you as an employer have to do this, if it's a reasonable precaution, then an employer is going to have to do that. So in the context of COVID-19, you know, there's no definitive answer, and every precaution is going to depend on the nature of, you know, the actual space of the workplace, the industry, how many employees work there. But you know, the idea is that employers should be taking precautions that that make sense in the, you know, in the context of their business. So I think one of the big ones is posting signage. I think education resources are probably our best tool in this, you know, in this battle. So, you know, signage that sets expectations for employees and also for visitors to the workplace, if it's a kind of workplace that that accepts outside visitors. So warning individuals not to enter if they're experiencing symptoms, encouraging people to practice hand hygiene and respiratory etiquette, signage that assists with movement and flow in the office. So, you know, again, if it's big enough, can this corridor be designated as, you know, a north to south corridor, and this corridor is going to be a south to north corridor, limiting the number of people in common areas. So I think those, I would think as a minimum, you would expect to see those at the workplace. Other measures could include screening individuals. So before they enter, asking questions as to whether they're experiencing any symptoms, asking workers to self-monitor for symptoms and remain home if they are experiencing any symptoms. As Antonio mentioned in the poll, providing personal protective equipment and ensuring that it's used properly, and you know, potentially erecting barriers or screens to you know, to prevent airflow between employees. So, you know, not this is not an exhaustive list. I'm sure others have thought of other ideas that I haven't thought of myself. But you know, the idea is, you know, be creative and also come up with decisions that are going to make sense in the context of your workplace. From the employee's perspective, as I mentioned, the OSHA has obligations for employees as well. Employees need to comply with OSHA. They need to wear any equipment that they're required to wear by the employer, and they need to report the existence of any hazard. So in the context of COVID-19, that definitely includes whether you or someone you live with is experiencing COVID-19 symptoms. And you know, just so everyone is aware, you can't be punished as a result of complying with OSHA. And if you are punished as a result, if you're suspended or fired, we definitely recommend seeking legal advice as a result. But you know, the main point that I wanted to get across here is that you know, OSHA, the idea or the objective is a health and safety workplace. And for that to happen, both employers and employees need to work together. It's not, you know, if it's the employer that has good policies, well, that's not going to help if none of the employees are following it. And if you have safety conscious employees, well, there's only so much they can do if you don't have an employer that is, you know, that has safety as a main priority. So, you know, think about or take the stance of cooperating with your employer, voicing concerns, so that those safety concerns that we saw in the poll of contracting COVID or of businesses not taking enough precautions, you know, hopefully through communication and cooperation, those concerns can be minimized. Because otherwise what you're left with is what Antonio is going to be talking about next, which are refusals, work refusals, which is a right that is stipulated in OSHA. So, Antonio, if you want to take us through that process. Oh, Antonio, I think you're still on mute.
It happens in Parliament, it can happen here. So thank you, Nadia. Before we go to the next slide, which is work refusals, what I understand is that there are many ways to prevent the spread of COVID-19 in the workplace. And you could be creative together with your employer if you're the employee, and the employer can be creative with the group of employees if you're the employer. But that creativity needs to be reasonable, right? Because we're talking about a very contagious disease, and there are many measures out there that are proven to control the spread of COVID-19 that could be applied. It's just a matter of understanding the nature of the business. That's what I understand, right?
Yeah, I would agree with that. And the Ministry of Labor, in conjunction with, I think about 4 different associations, have come up with guides like specific to certain industries about when you do reopen, here are the kinds of things that you should be doing. So you definitely want to look at it from, I mean, like I said before, just because something worked in this workplace doesn't mean that it automatically has to happen in every workplace. You do have to, there's industry specific resources out there, and to the employers in the audience, we definitely recommend reviewing those, and even to the employees, if you want to have some kind of basis for why you're proposing something to your employer. A government published resource is probably going to be the best resource out there.
And the second question I have quickly, Nadia, is the poll suggested that there are some of the participants were concerned about commuting to work, but the employer's responsibility ends in the workplace. It doesn't extend to commuting. So in the commuting piece, it is the employee who needs to take some precautions.
Definitely. I mean, I think, not yesterday, but last week, I think I saw an announcement from the TTC saying that masks are going to be mandatory in all of their, buses, subways. Having said that, I'm sure there are exceptions to that. If someone has a disability, which means that they can't use a mask, the TTC might have a duty to accommodate that. And this is assuming that everyone in the audience works in Toronto, which, that's,
right.
That might not be true if you're in the suburbs. So yeah, I mean, it is a complicated question, but as I said, I mean, it's really, everyone needs to cooperate and make an effort if we're going to, return to some sense of normalcy here.
And I like what you said, that it's, yes, the employer has the responsibility based on the OHSA, but the employees also have a responsibility, and a little bit more than that, it is good that we take initiatives to prevent the spread of COVID-19 together, because it is a highly contagious infectious disease. These are unprecedented times, and it's better if we work together. So taking your point about work refusals, I like what you say, Nadia, in our podcast. Work refusals is not a get out of work card. And work refusals, yes, it is a right of an employee, but it's a very limited in time measure. And the purpose of that right is for the employee and the workplace to fix whatever is creating a dangerous whether environment or an equipment that is not working properly, or a machine that is not working properly. So the purpose of work refusals is to fix what is not working properly in the workplace, creating an environment that it's dangerous for the workers. It is a right to refuse or to stop work where health or safety is in danger. That's the language of the Occupational Health and Safety Act, OHSA. It's basically, an employee could say, I'm not going to perform this particular task, or the employee, the machine doesn't work, or it's not working properly, or my personal protection equipment is broken, or for any reason that creates some danger, but it's also saying I'm not going to work, generally speaking. And that's happening a lot now because of the sort of COVID-19 in workplaces. There is a, we're talking, by the way, about Occupational Health and Safety Act in Ontario. I'm not sure where you're listening to these webcast from, but we're talking about specifically in Ontario. However, I want to point out to an example of an Alberta meat plant factory that had to close for a couple of weeks because there was an outbreak of COVID-19. And when they reopened, employees were afraid of returning to work. And that means that I'm not going to work in general. I'm not going to the workplace even. And now employers have to think about, well, I'm gonna just clean even more and barriers in play, and that they in this case of the Alberta meat plant did, just to make it safer for the employees to return. But that's an exceptional circumstance where you had an outbreak of 900 employees, 900 employees who got COVID-19. Unfortunately, a couple of them passed away. I think 3 of them passed away. That's not the general situation. But my point is that the employer has to fix whatever is creating the dangerous circumstances. And once it's fixed, then the employee needs to return to work. So if we're talking about, I'm refusing because these personal protective equipment is not protecting me in these circumstances, and the employer fix it, then you have to return to work right away. If it's a larger outbreak, then you may refuse to just go to work, and then the employee fixes it. So when the employer fixes the situation that it's creating the dangerous circumstance, and the employee insists in not returning to work or stopping work, the next step after that is that the Ministry of Labor is called to do an inspection. And we were talking about this, Nadia, in the podcast, that the Ministry of Labor will go there, an employment standards officer, an inspector will go there and check the circumstances in the workplace, and will make the decision whether the dangerous circumstances is there or is not there anymore. And once that's done, the employee needs to return to work. So most of the inspections conducted so far, employees had to return to work. So it's not a get out of card, as we said, and it's a very short in time measure, and it's to fix whatever is creating the dangerous circumstances. So what I will do now is to invite you to listen to the podcast. And Nadia, I understand that the podcast has no cost; it's publicly available, and we talk about work refusals and health and safety in the workplace, right?
Yeah, so it's available on Apple Podcasts, Google Podcasts, and Spotify. It might be available on other platforms as well. But I guess the point is, you know, we dedicated a whole episode to that. We're just scratching the surface here to let you know it is a right that you have, and you know, feel comfortable in using it, and comfortable in knowing that you should not be punished as a result of claiming that right. But it does have its limitations. And as Antonio said, and we get into quite a bit on the podcast, so far those complaints have not been substantiated by the Ministry of Labor.
Mm-hmm. And Lucero, by the way, when you receive these, I mean, you have presentation slides. If you share it with the audience, in the picture, you will have the link to open up the episode about work refusals. I invite you to listen to it or get information from other sources. So let's shift gears and talk about wage subsidies and work sharing. These are emergency responses from, well, work sharing was there before, but these are emergencies from the governments, federal and provincial governments, to support businesses and payroll employees. So Nadia, can you talk to us about wage subsidies?
Yeah, thank you. So when this first started happening, so early March, the government announced that a 10% wage subsidy, and it was only going to be for small employers. And there was a specific definition about which employers would qualify for that. And the kind of response from, from the from the employer side was, that's not going to be enough. The subsidy needs to be a lot higher, and really available to everyone if we're going to make it through this crisis. And so in around mid-April, the government passed a second subsidy, and that is the 75% subsidy called the Canada Emergency Wage Subsidy, or CEWS. And that is to cover up to 75% of salaries for qualifying businesses for up to 3 months. And it was retroactive to March 15, 2020. So even though the actual legislation came in April 2020, it was retroactive to March 15th, because that was generally the week where I think most employers started to shut down. So the purpose behind really either wage subsidy is to prevent further job losses and encourage employers to recall workers that were previously laid off as a result of COVID-19. The idea being that, well, if 75% of the salary is being subsidized by the government, then that should motivate some employers to put employees back on payroll, even if they aren't necessarily providing services at the time. So in terms of eligibility, employers needed to prove that they suffered a loss in revenue of 15% in that first period, which was around mid-March to mid-April, and then a 30% loss of revenue for each period after that. Now, I said at the beginning, originally it was supposed to be for 3 months, although I think it was just last week, maybe, or no. Last month that the government announced that it would be extended for an additional 12 weeks. So now an employer can receive this subsidy until I think around August. Now, we've been calling it the 75% subsidy and referring to that figure, but it does cover 75% of salaries up to a maximum benefit, which is $847 a week, which comes up to around $44,000 annual salary. So, I guess it is a bit misleading to say that it covers 75%, because for some high earning individuals, it's going to cover far less than that. Although on the flip side, it is quite a lot more than EI, for example. The other kind of caveat, or the other question that I think employers and employees are struggling with, is what happens with the additional 25%, or for a high income individual, what happens to just the remainder of the salary? And unfortunately, there is nothing in the legislation. Antonio, I don't know if you've noticed anything more recent, but the last time I took a look, there's nothing in the legislation that requires employers to top up their employee salaries to the pre-crisis levels. The most that I've seen is that the government strongly encourages employers to make best efforts to maintain people's pre-crisis levels. But again, there's no obligation, there's no penalty if they don't. It doesn't mean that they're disqualified from receiving the subsidy. So there's really nothing, there's really no strings attached in that way. which means, and perhaps some of you started being recalled back to work back in April, or at least had their wages reinstated around April, but you might have been asked to take a pay cut, and that pay cut may be kind of around the 44,000 that I just cited. So this subsidy would explain why. It is a temporary measure. Of course, as I said, it was recently extended for another 3 months or another 12 weeks. Who's to say whether it will be further extended? But if this is an offer that is made to you, then I think it's completely open to employees to to accept. And to make clear, or at least to clarify that this pay cut is going to be a temporary pay cut, and that eventually they will be returned to their pre-crisis income levels. So I think that's probably as much as we need to talk about that, because I don't think we saw too many employers in the audience. Although I think, Antonio, you've been helping employers with applications, haven't you, or have you been working more with the work sharing applications? Sorry, I think you're on mute again.
It happens in Parliament. It can happen here. Thank you, Nadia. So I have a question for you, because my employer comes to me and says, well, you're earning, let's say, $1,000 a month. I can't afford it because of COVID-19. We don't have much business. I have the wage subsidy from the government, and I'm going to apply to that, and you're going to get $750 a month. In the work sharing program, there is a contract, which I will mention in the next slide. But with wage subsidy, what do you think is a good practice to have if my employer comes to me and says, Antonio, you're going to receive $750 from now until this is over? And he says that to me, or she says that to me verbally.
Mm-hmm. Well, I think it's, we could probably go on and on about wage reductions. And in fact, we're going to be covering it a little bit later. But just as a general comment, certain wage reductions could be constructive dismissal, which is when an employer unilaterally changes a fundamental term of your employment contract, and what can be more fundamental than compensation. And when I say certain wage reductions, that's because as I said, it has to be significant or fundamental. So a 5% reduction, that's likely not going to cut it. 25%, as Antonio is suggesting, that might be more in the realm of a constructive dismissal. But the reason why I bring that up is, I think if the employer is saying it's a temporary measure that is a part of this emergency situation that the entire country, or really the entire world, is in, whether you're going to be successful in bringing a constructive dismissal claim remains to be seen. But having said that, one problem is you don't, or one way to defeat a constructive dismissal claim is for the employer to convince the judge that the employee condoned the change. And so this is where that kind of recommendation that I made to kind of clarify, and when I say clarify, I mean in writing. So even if as Antonio said, if you get a call, that's fine. Just make sure you follow up that call with an email that summarizes what was discussed and what was agreed to, and that you are agreeing to it as a temporary measure. That would be my 2 cents on that.
Email or a message or a WhatsApp text, right?
Yeah, it's 2020, so.
All right. So So Nadia, with work sharing program, it's a little bit more clear because you have with work sharing program, this is a program that existed before. This is an employment insurance program, and the idea behind this program is to support companies to recuperate if they lost income for some reason. It doesn't have to be COVID-19, but for some reason. The range of losing income or revenues for the companies to qualify for this sharing program is between percent and 60%. The difference between the work sharing, so let me back up. The business lost between 10% and 60% of the revenues that they had, and they qualify for the work sharing program. The difference between this work sharing program that we have during COVID-19 and the work sharing program before is the length of the program. Before it was 30 something weeks. Now it goes over 70 something weeks. So it's more than a year. It's basically an agreement between the government, the employer, and the employees. So employees need to be on board with the work sharing program. And what this program basically means is that, like the sentence says, work sharing program, work sharing is that the business has less revenue, less work to do, and they're gonna spread among all the employees of that group the work that they have. So if I had, let's say that I'm in a 10 people work group and we had 400 hours, the 10 people, we had 400 hours of work a week. So 10 people, 400 hours together of work a week, but now we have half of it. The employer can decide to temporarily lay off half of the employees or to share the 200 hours among all the employees. But that means that instead of me working 40 hours, I'm gonna be working 20 hours a week, right? I may choose to accept that through the sharing program because I'm gonna have access to employment insurance. That way we all keep our jobs, 10 people in the group keep their jobs, nobody's temporarily laid off, and we keep our skills up to date, because when we go on layoff, then we start losing the update of our skills. So we lose very little money, if we lose any money, and the employment insurance piece of it will cover portion of what I'm missing from my financial compensation. The employer is going to pay for the remainder, the hours that I'm actually working. So in my preference, I would lean towards work sharing program over the wage subsidy because it's more sustainable. It's longer. It's people gets involved into this agreement. Having said that, it's a little bit more complicated and complex to fill out these forms and to sign these agreements, to send it to the government, to qualify and open up the employment insurance piece for the employees, and there are tax consequences. So work sharing program is a little bit more complex than the wage subsidy, but I think at the long run, it will help companies better and employees better. But every case is different. This is a temporary measure. It's not permanent like the wage subsidy. And I think that's what I can say about the work sharing program so far. Let's do a poll. What do you think? Let's open up our third poll. I love polls. So here it is. So for our participants, which program do you think is more appropriate to your circumstances? Wage subsidy? And if you're an employer, then what do you think it's? I don't know if you see this answer, but none of them. So wage subsidy, working program, both or none. I'll give you seconds to answer what program is best for you.
So that's interesting. Your comment on finding like work sharing program more sustainable. I mean, I think I would probably, I think definitely as an employee, I would probably prefer the wage subsidy, because the work sharing program like there's an assumption that there is work to be shared, which isn't going to be the case for every employer. Whereas with the wage subsidy, there's no requirement that employees need to actually be performing services. They just need to be returned back on payroll. So.
Yeah, and that's correct, Nadia. My perspective is from the sustainability of the business. So I'm thinking, and I'm assuming for my preference, I'm assuming that the company has some work to share. Yes. It's not like a pub that needs to be closed or a restaurant that needs to be closed down. All right, let's see the results. We have work sharing program 50% and none 50%. Thank you for letting us know. This is interesting. All right, let's go to temporary layoffs, changing gears. And if there are questions, please put it in the Q&A box and we'll answer the questions in a few minutes. Let's move to temporary layoffs and terminations and your IDEL, Nadia. Oh, we have another poll. Is it too much polling? Let's see. Workstation. Did you experience or are about to experience temporary layoff, termination?
I don't see, okay, never mind. It just showed up. Yeah.
Okay. So did you experience or are about to experience temporary layoff, termination, and IDEL is infectious disease. Go ahead, Nadia.
Infectious disease emergency leave.
Let's see in a few seconds. Let's give it a few more seconds. Five more seconds. And this is what we have. 75% layoff, 5% termination, no IDEL. All right, let's see what that is. I start with temporary layoffs, right?
Mm-hmm.
Okay, so temporary layoffs is the Employment Standards Act as a minimum standard legislation for the employment relationship. It sets up the minimum things that the employer-employee have to do, rights and duties. Temporary layoffs are supposed to last in Ontario up to 13 weeks, no more than that. There are some circumstances where it could last longer, but the basic one is 13 weeks in a period of 20 weeks. So every 20 weeks, it restarts. After 13 weeks, according to the Employment Standards Act, the temporary layoff becomes a team termination, meaning that, well, if the employer didn't recall the employee back to resume work, that temporary layoff of 13 weeks, passing 13 weeks becomes a termination, and it is considered from the moment that the temporary layoff began. For an employer to use a temporary layoff, and this is under traditional circumstances, not under COVID-19. For an employer to use a temporary layoff, it's supposed to be in the employment agreement, whether in writing or that the employee agrees to the temporary layoff at some point when the temporary layoff is offered. If it is not in the employment agreement and the employee doesn't agree with the temporary layoff, the employer cannot unilaterally, by its own will, temporarily lay off the employee. I repeat that. If it's not in the agreement and the employee doesn't accept the temporary layoff, the employer cannot by itself temporarily lay off the employee, because that would be considered a constructive dismissal. And what that means is that the employee can go and file a lawsuit for wrongful termination against the employer. This is under traditional circumstances, but it's not under COVID-19. And I think that we're going to talk about IDEL in the next slide. You had a point about any of these bullet points, Nadia?
Well, I mean, I guess just to clarify what I think you mean by saying this is in traditional circumstances, not in COVID-19. I think the point is, you know, we can only really say, or I guess to make the distinction, the Employment Standards Act has rules about temporary layoffs, how long they can last, and as Antonio said, if they pass the deadline, then it's a deemed termination. And I think a lot of employers have learned this, especially in the last, you know, in these last couple of months. But a lot of employers thought that as long as they complied with what the Employment Standards Act says about temporary layoffs, that they could lay off an employee. And as Antonio pointed out, that's not the case. Like they actually have to have an agreement from the employee, and the one exception is if you're in if the employee has historically accepted layoffs, then it becomes an implied term. But other than that, you need a specific agreement. But where I think Antonio is saying this is under traditional circumstances is, yeah, historically, this is what judges have found, that unless you have that right in an employment agreement, you are not allowed to lay off an employee. But we don't know if judges are going to feel the same way. We don't know if judges are going to be sympathetic to employers that may not have negotiated for that right because they weren't in industries that ever really suffered downturns, and so they didn't turn their minds to putting that in their employment contracts. But you can be assured that the employer is going to argue, well, you know, it was a global pandemic, or in cases where, as you said, a restaurant or a hotel where you're actually being asked to shut down by the government. Right. You know, what option did the employer have? So this is it is the status of the law. Like I guess I would put it a different way. It is the status of the law that you need that agreement. The problem is we don't have any cases before the courts to see if judges are going to change that status in light of this current emergency. And it takes at least 1 year, if not 2 years, for cases to make their way, you know, through the court system. It's going to take even longer given the closure of the courts. So I don't suspect we'll have a firm answer on this until you know, until 2021, 2022, maybe.
So Nadia, sorry, go ahead.
No, so I mean, I guess I was going to say, I mean, what I've been telling my employees, employee clients is, yes, this is a right that you have, but, you know, like I recommend the wait and see approach, especially if you don't want to sever the relationship, and see if you know, if things look up in a month, 2 months, 3 months from now. So that's kind of the situation we're in.
I'm thank you, Nadia. I'm mindful of everybody. We are mindful of everybody's time. I'm going to cover quickly terminations as a distinction with temporary layoffs, and we'll move to IDEL because I know that you are dying to talk about IDEL. I can see it in your face. So terminations, the difference between termination and temporary layoffs, evidently the termination, it's actually the person is fired, the employment relationship ends, the person is no longer in the payroll. And at that point, in Canada, in Ontario in particular, an employer is able to terminate an employee at any time for no reason, as long as the employer complies with the Employment Standards Act and the termination is not discriminatory or made in reprisal for raising rights under these legislations, Employment Standards Act, Human Rights Code, Occupational Health and Safety Act, and others. The employer, when the employer decides to terminate an employee, it must provide notice to that employee based whether on the Employment Standards Act, if there's an employment agreement in writing with a valid termination clause that says the employer and the employee agrees to, at the time of termination without cause, to be bound by the Employment Standards Act, and has a formula to say how much the employee will receive at the time of termination if the employer decides to do that termination. So notice is the go-to that you will see in employment agreements where the employer says, this is how much you're gonna be entitled to if the employment ends without cause. There are two, before I go, so the alternative to that notice is the employer can keep the employee working, and instead of giving notice, it pays the notice. It means that it will pay the amount that the employee would make for that time of the notice period, but the employee does not continue to work. The difference between what you see there in the slides is a distinction that is made here in Ontario and in Canada in general, whether it is based on the Employment Standards Act or based on precedents. And this is an important distinction because the financial difference is substantial. Under the Employment Standards Act, the cap for a termination notice, without including severance, the cap for a termination notice under the Employment Standards Act is 8 weeks. No more than that. You could work with the employer for 30 years. You're gonna get 8 weeks of termination pay. That's the cap. Severance is another question. I'm just talking about termination notice here. Under judicial precedents, there is no cap. They usually say 24 months, not weeks, but months is the traditional cap, but it can go over 24 months in special circumstances. So you see that the judge-made law says that the termination notice is way higher than what the Employment Standards Act says. We put this distinction there because it depends on whether you have an employment agreement with a termination clause that is valid or you don't. That will go to the Employment Standards Act or the common law. Why this distinction is important? Because usually an employer and employee use the Employment Standards Act as the law to terminate an employee, but in reality, there is no employment agreement in writing with a valid termination clause, and they're supposed to use common law for that termination. So a higher termination notice. Do you have any other point, Nadia, with the termination clauses?
No, I think we've covered this pretty well, and we do have one last topic, which I think is quite important because it's a very recent change in the law. We're just gonna kind of zip through it because I know we don't have much time, but as the icon on the screen shows, Antonio and I did a podcast on just specifically this subject, so feel free to check it out if you want to learn in more depth. So the basically, again, we're talking about the Employment Standards Act here, which has always included various leaves of absence. So the one that most people are familiar with is pregnancy and parental leave, but it has a whole, you know, I think maybe 11 or something like that. And one of the leaves is the emergency, a declared emergency leave. Now in March, there was a change in the legislation which just included infectious disease emergency as part of this declared emergency leave. So now there are job protected leaves for employees to take if they cannot work for a reason that is related to a designated infectious disease. And right now, the only one that is defined is COVID-19. So there's about 6 reasons. You know, most of them have to do with, obviously, if you are under medical supervision because of COVID-19, you can take this emergency leave. If you if you've been ordered to quarantine, whether by your doctor or even by the government of Ontario or Telehealth Ontario, then you can take this leave and protect your job. So the one example I can think of is like it doesn't have to be your doctor specifically, like it could be an order from the government. So if there's an outbreak, say at a Home Depot, you could see the government saying anyone that visited this Home Depot needs to quarantine for 2 weeks. And so so now you have the ability to take this leave. I think the other one that we're seeing a lot is if you are either taking care of a relative for COVID-19 reasons, or just taking care of your child because their school or daycare is closed because of COVID-19. So I think those are the three biggest. There's three more, but like I said, we don't have time to go through all of them. So that was the lay of the land in terms of infectious disease emergency leave. And then there was another amendment. And Antonio, do you want to tell us quickly
Yes.
what that did?
Yes, thank you, Nadia. On May 29th, the Ontario government released a regulation about the infectious disease emergency leave. And a couple of points that are important there is that the Ontario government said in that regulation that employers are able to reduce employees' wages or hours of work. And specifically with hours of work, they say partially or fully. So they can go to zero hours of reduction. So I mean, total hours of reduction. So the employee has 0 hours to work, and it will not be considered a temporary layoff. And we talk about this in the podcast a little bit further, but the government is doing there is trying to protect jobs and keeping people in payroll. Another important point that we can probably mention in the next 30 seconds is the period that this legislation is working on. So it starts working in, it's that COVID-19, it starts working on March 1st, 2020, and it continues until the declared emergency is lifted, plus 6 weeks. So 6 weeks after the government says there's no more declared emergency is when this COVID-19 period ends. And that's important because that's when the employer and employee need to return to normalcy. And the temporary wage reduction and the temporary hours reduction, if they're not brought back to what it was before COVID-19 period, then it's easier for us to understand that it is a temporary layoff. But at this point, according to that regulation, it is not. Let's just refer you to a couple of to the Canadian Hispanic Bar Association. Lucero, do we have a couple of minutes to talk about the Canadian Hispanic Bar Association?
Yeah, sure. We have 1 minute. Is that enough?
Yes, okay. So the Canadian Hispanic Bar Association is the organization of Canadian lawyers who identify with Hispanic and Latin American background. There is a lawyers directory in the Canadian Hispanic Bar Association's website. The link is there when you receive the slides. And I invite you to see, if you have a question about whether it is an employment law matter, whether it is about intellectual property, whether it's about a criminal law, whatever it is, family, divorce, whatever it is, the Canadian Hispanic Bar Association has about 60 lawyers in that lawyers directory that are able to provide services in both English and Spanish. Nadia, do you want to mention the scholarship that we have?
Oh yes, we are funding a high school student that identifies as Hispanic or Latinx to take part of a summer program at the University of Toronto that deals with the law. So for any high school students that might be considering joining the dark side, no, I'm kidding. Might be considering studying law, you know, we're supporting this this initiative. So.
And it's between grade 10 and 12, right?
I believe so. Yeah.
Okay, thank you, Nadia. All right, Lucero, your turn.
Okay, it was great listening about the right and duties in the workplace. So now, we have 2 questions. So the first one is, As an employer, what do we do if the employees refuse to return to work even after all precautions are taken?
Mm-hmm. So now that you want to take on this one as an employer, what do we do if the employees refuse to return? I guess that this is when it's a work refusal, then there is an inspector, and then the Ministry of Labor says come back to work, and still the employee refuses to return.
Right. I mean, yeah, I think the stage in which we're at is going to inform the answer a lot. And I guess obviously the province, because like Antonio said, we've been exclusively, with the exception of the federal programs that we discussed, with the wage subsidies and the work sharing programs, like pretty much everything has been in the provincial context. But I mean, assuming that the employer has involved the Ministry of Labor as they're required to do under OSHA, and that the Ministry of Labor has sided with the employer, or even recommended precautions to be implemented, and assuming those have been taken, well, I would think a continued refusal, then it's not a reasonable refusal at that point. And so as an employer, you do have options. And again, I want to stress it's a very big decision, and you want to have legal advice before you do. But it could be taken as a repudiation of the employment agreement, and in which case, as I said, the employer has certain remedies that they can take.
And Nadia, may I jump there? So what I understand is that the employee is sending a message to the employer that they don't want to continue to be bound by the employment relationship agreement with that employer, right?
Right. I mean, yeah, that would be the repudiation, right? Because
right.
As the employer has a duty to provide a health and safe workplace, and if they're doing that, and not only that, they have a government officer that is agreeing that they're doing that, well, then in that case, like in that scenario, it's the employee that is not holding up their side of the bargain. But again, as we said at the beginning, each case is going to depend on the facts. There could be some human rights elements, disability. So we don't, just based on this question, we don't know that. Yeah.
Yeah, but in general, yeah, every case it's going to be different. Lucero, do we have another one?
Yeah, that's the last one. I don't know if someone else wants to add another question. This is the time, please. So the question is, if the employer declares bankruptcy, do employees lose their severance pay?
Interesting question. So first of all, severance pay needs to be, let's separate termination pay from severance pay. Termination pay, and jump in, Nadia, if you want to try to answer this complex question. Termination pay is every employee is entitled to whether notice or termination pay. Severance pay is for those employees who've been more than 5 years with the company, and the payroll of that company is over $2.5 million per year. So there are requirements for qualifying for a severance pay. If we're talking about termination pay in this question, if the employer declares bankruptcy, do employees lose their severance pay? If we're talking about termination pay, an employee will not lose the termination pay, the right. The thing is that they will be put as a creditor for that company when the company, I mean, not the company, but the bank organization, it's releasing the funds that they recuperate or recover from selling assets. So an employee needs to pay attention to I mean, not the employee, but the group of employees need to pay attention to put themselves as a creditor for that bankruptcy procedure. Am I in the right ballpark, Nadia?
Yeah, I would agree that unfortunately, it's not that you lose the right to it, but you know, you can't, you know, you can't squeeze blood out of a stone. Like if there are no, if the employer is truly bankrupt,
Right.
then you're not, you know, you're not going to be able to recuperate. There is the Wage Earners Protection Program, where the government does pay out a certain amount to employees in this scenario. I think it's about 2,000 to 3,000.
Yep.
So depending on the employee, you know, that might cover it. It might not. I think the other thing to keep in mind is under the Employment Standards Act, you can go after individual directors for certain wages, but unfortunately, those wages do not include termination pay and severance pay. So if you're terminated, but you're still owed wages, and you're owed vacation pay, if you're owed overtime, not all is lost, because you can go after individual directors, but you can't go after them for termination and severance pay.
It's funny how you say you can go after the individuals, but after a long procedure of bankruptcy when the corporation cannot pay, right?
I don't think under the ministry proceedings, I think you can go after, like, I think they can be done at the same time. Like, I don't think there's a, like, I don't think they'll make you wait until the bankruptcy proceedings are finalized.
Okay.
But they could, and then, I mean, by the, you know, and then you don't really know like how involved this director was, whether they were in name only or whether they actually do have access to funds. So yeah, I mean, there is kind of an expectation that you will go after both the employer and the individual. I just don't know that, like, if it's very clear that the company is bankrupt, I don't think the ministry necessarily makes you wait until it's all done.
Mm-hmm.
Yeah.
Yeah, and I'm happy that people stayed with us to talk about geeky legal procedures. We appreciate it. Sir, is there something else in the chat box or questions and answers?
There is nothing else. The link for the slide is already in the chat. Also, as well, the link to the podcast, your podcast that you have.
Thank
so
you,
it's
Lucero.
already there if you want to open them. And that's it. Thank you.
Well,
Thank you, Antonio.
Before we go, the resources, you have the slides there. You have the Ministry of Labor website, Pro Bono Ontario, Public Health Canada, Public Health Ontario, and the work sharing program, the lawyers directory, the podcast, all the resources are available there. Thank you, Lucero. Thank you for having us.
Thank you to all the participants, and have a good night.
Bye.
Thank you, everyone. Bye-bye.